Well, my position is I shouldn't have had to go through the extremities of having to come to court twice to get. I'm living with a lot of mold. I showed them the video just as like a little portion of it, and it's horrible. And if you're waking up every day and living with it, it's dangerous to live with. And I've been telling them about this for over a year. And I've been.
But they were trying to get into your apartment.
I am requesting the transcripts and the so-called notes you received from Wellpath and Lieutenant Arnett concerning my tooth extraction, where they said I would take injections.
Notes I
Yes,
received
that you stated on the record
that I had a conversation. Yeah.
from Wellpath and
No,
people
I
who
have not
charged
talked to
you
you
with
about
crime.
that. I've not talked to anybody.
Well, you received notes from someone saying
No.
that I refused to take injections in
No,
my
I
mouth.
received, that was a oral communication
Oh, well,
saying
okay.
that was it.
Told
And
me it was notes.
I informed the parties exactly of that communication.
Well, it was a blatant lie. My religious beliefs tell me
I
not to
don't,
take any
Mr.
medication,
Bloom,
sir.
I don't know. That's why I informed everybody
Well, you
of
took
what
it
I had heard.
so I just wanted to put that on record. Thank you very
Okay.
much. Have a
Court does call the case of Arbor One West versus Chauncey Hang.
Good morning, Your Honor. Cheryl Lunkoff on behalf of the plaintiff.
Good morning, Your Honor. Jill Bauer here, on behalf of Mr. Hyman, who is also present.
All right. All right, go ahead and see. Motion.
Yes, Your Honor. Your Honor, we've moved the court to set aside the judgment that was issued on March 15th and to participate for lack of jurisdiction based on the CARES Act requirement that Mr. Hyman be given a 30-day notice before any action can be taken against him. And I know the court is very familiar with the CARES Act.
And then whether or not it's waived, because I don't consider it jurisdictional, but you haven't raised this before now, correct?
In this case,
Yes.
no, Your Honor. I did not I stepped into this piece of Mr. Hyman's case. I was handling his voucher termination, and I stepped into this case to cover the court hearing. And then after reviewing the documents, I discovered the CARES Act issue and filed this motion. So, but I did cite law that said that I know the court said you don't consider it jurisdictional, but
I don't consider it jurisdictional. I consider it realistically to be an affirmative defense, which if not waived.
well, we presented it as jurisdictional and also case law that says it can be jurisdictional. Arguments can be raised at any time.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. Right now, this case hinges on a critical legal distinction. The defense is arguing that the CARES Act issue affects the court's authority, while the judge views it as an affirmative defense that should have been raised earlier. That difference could decide the entire motion before anyone even discusses the underlying facts. Keep watching, because the judge's reasoning here will determine whether this case moves forward or comes to an abrupt end.
Correct, but I don't consider it jurisdictional because the state statute confers jurisdiction on this court. The plaintiff complied with the state statute. The court has jurisdiction. The question is to the length of the notice. In this court's mind is an affirmative defense that can be raised, but if it's not raised timely, it's then waived.
Okay, well, I would respectfully
Disagree. I know.
disagree.
I know. Anything for the plaintiff?
No, Your Honor. The only thing that I would add is that it's the Arbor One West is not a covered property under the CARES Act in any event. But no, I'm just respectfully requesting you deny the motion.
And Your Honor, if I could just briefly respond to that. The Register of Deeds described the mortgage property, the mortgage that I provided. It said that it clearly included the city side, not the township side. And so I'd like the plaintiff to produce proof that mortgage has been superseded by another mortgage that's not federally backed. And then I'd like to also assert that because they
Now,
accept.
isn't that your burden? Why are they producing it?
Well, Your Honor, I produced what was filed with the Register of Deeds that appears to show that it's covered property.
Your
I
Honor,
believe that-
this is, excuse me, because I can just short circuit this, and I apologize because I filed this affidavit at 5 o'clock yesterday, but what defendant's counsel attached was for the wrong property. And so, but this is all moot based on the court's finding that this isn't a jurisdictional issue. But just for clarity, that was Arbor One West, which she attached to her motion. I mean, excuse me, Arbor One, not Arbor One West, the exhibit. So
She attached Arbor One and not Arbor One West.
correct.
And Arbor One West is not a covered property.
Correct.
Your Honor, I would just argue, as I did in the motion, that we can accept Section 8 vouchers. That's another basis through the CARES Act for a property to be determined to be a covered property.
Anything else?
No, Your Honor.
The motion to set aside the judgment and dismiss the case is denied.
Thank you, Your Honor. Have a good day.
I'll prepare an order to that effect and email it to the court yet today.
All right.
Thank you.
Let's call the case of Glencoe Hills versus Jerome Adams.
Good morning, Your Honor. Carissa Gazari. And my client is here as well.
All right. Your name?
Wrong.
All right. Where are we on this case?
Discussions. We haven't been able to reach a resolution as of yet. Mr. Adams, at the last hearing, indicated that the repairs were not completed to his satisfaction. He said he was going to send me a video, and again, the video was too large to send. Maintenance tried to reach out to Mr. Adams to do an inspection. Sounds like they may have had a different phone number for him. So they haven't been able to go in. He has provided permission to enter today between 1 and 4, and also provided just a blanket permission to enter, which is going to be really helpful to get the, to have maintenance go in and inspect. The issue that we have is, I think Mr. Adams does not dispute the rent and utilities, but he's disputing late fees and court costs. And from plaintiff's position is that work orders, the last work order was submitted in November and it was closed. And then the last that they heard of any issue was in March. So that's plaintiff's position.
Well, my position is I shouldn't have had to go through the extremities of having to come to court twice to get. I'm living with a lot of mold. I showed them the video just as like a little portion of it, and it's horrible. And if you're waking up every day and living with it, it's dangerous to live with. And I've been telling them about this for over a year. And I've been.
But they were trying to get into your apartment.
This is since the court. This is since the court proceedings has been going on. This is like the last couple weeks they said that, and they've always had permission to go in because they've been going in my apartment for anything else. They just went into they called and went into my apartment on March the 14th. Court was 15th. They said they can't get in contact with me. They was able to get in contact with me the day before court and miraculously come in there and do just a little strip of what I had a video of. That's the only thing they did. My thing is when it's mold, they will have to. It's a small section, a tub flooded up over my apartment. So that whole ceiling has got water damage that is just popping out like potholes of mud, of mold. And it was over in the corner, it was in the middle, and it was in the right. What happened is I could show you the video, Your Honor. I don't know how I would do that. I could, but it peeled back what they spray painted, and you can just start seeing the mold again. And they just came and repaired where you could see it again.
But they were trying to get in to do repairs.
They just been trying to get in to do repairs since we went to court on March the 15th. They said just since March the 15th that they were trying to get in to do repairs. On when we went to court March the 15th, they said since then. We went to court March the 14th, and they was able to get in contact with me and go.
Well, you were here March 8th.
or what was that, March 8th that we was here? What was the March,
Then you were here on the 15th.
okay, so yeah, that's what I'm saying. On the 14th, they called me on the 14th, the day before court, like 4 o'clock, 3, 4 o'clock, he called me about, can we come in right quick and do the repairs? Because they hadn't been trying to get in contact with me before. And they said they didn't have the information, but they had it the day before court, out 16 hours. before
Okay.
court, they had it.
That's fine.
Yeah, and
I guess,
never
are they
called.
gonna get in today?
Yeah, they always had permission. They've been going into my apartment forever, doing all types of.
I just want to clarify something for the record, is that when we were here, it was me that was here on March 8th, and I asked you if there was permission to enter, and you said no. But we negotiated a time at that hearing.
That's-
They would come in at 4 o'clock to do the repairs. That was not, I specifically asked you if they had
I said,
permission
I'm
to
gonna go home.
No, that's, and I'm gonna tell you, that's exactly what my notes indicate. My notes indicate there was a maintenance meeting at 4 p.m. that day.
I met them home because I lived, Glencoe was right across the street. They said, can we come in today? I said, yes. That's exactly what was asked is, can we come in?
Sir,
I'm sorry.
I'm telling you. What Ms. Gazzari is indicating was what the court has its
Yes.
notes. There was a maintenance meeting at 4 p.m. on the 8th.
And they came that day. On the 8th, they came that day, and that's when he came and seen all the mold on the 8th. Our video was timestamped for the 8th. He was there on the 8th. I showed him that on the 8th. And then he called me again. He didn't call me back until the 14th, the day before court. He called me back and said, can we come do the repairs today? They came and did them. They never came back since then. And he's saying that they couldn't get in contact with me. They never attempted to. They had permission. They always could come in. That's not a problem.
I just want, Your Honor, sorry, just to clarify one more thing. So then we were back in court after the repairs were done. And my understanding was that everything was done. I had pictures from my client and you said, no, I'll send you a video. And you sent me an email. And that's why we adjourned. Set a settlement conference. But the email that you sent me said the video was too big. I can't send it. And that was the last I heard from you.
Yes.
And then they tried to contact you, but apparently there was some miscommunication as to your phone. But that's,
Okay,
Usually they.
so they're gonna go in today. Is that the deal?
yes.
And they can come in whenever they want to fix that mold, just put that on court rate. They have standard permission to come in.
Okay, that's what's happening today to accomplish the repairs. I'll adjourn this to April what? April 30th, 2024, 9 a.m.
This is one of those landlord-tenant disputes where the courtroom becomes less about emotions and more about evidence. The tenant insists dangerous mold has been ignored for over a year, while the property management argues they've repeatedly tried to complete repairs. Instead of rushing to judgment, the court focuses on documentation, access, and verification before making a final decision. That's a reminder that in civil cases, proof almost always outweighs personal frustration. What do you think? Should the landlord have acted sooner, or should both sides have communicated better? Let us know your thoughts in the comments.
Your Honor, how much is an escrow right now? If you don't mind.
In escrow, I have a total of $25. Court does call the case People versus Jeffrey Bloom.
Prosecuting attorney working on behalf of people.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Bloom, present at the podium with me.
All right. Say, what are we doing today?
So I understand that the court's doing final settlement conferences on April 5th with jury selections on April 8th. Is that right?
That is correct.
I'm hoping to get this matter moving. I just kind of warned the court. I have a very firm trial scheduled on April 8th, so I don't know if I can be at jury selection for this one. Perhaps we could set this on April 3rd, and if there's some miracle that resolves my other trial.
April 3rd. Oh, you want to adjourn the pretrial?
Yes, Your Honor, just for, in case the other case resolves, I might be able to still make this one happen.
All right.
I mean, I recognize Mr. Bloom in custody. He's got bigger fish to fry at the moment, so it's not a.
It's not a, I got it. Okay.
Your Honor, I do just have to say, if we're setting this for final settlement, I don't think 48 hours is enough time
For you to get your witnesses, that's
So
correct.
if we're setting it, I would like to know now, and then I can send notice and call them off.
No, I meant, could we please just set it for the, sorry, I used the wrong words, just a pre-trial on April 3rd, if that's possible. And that way I can inform the court if we even need a final settlement conference. But you're saying,
Understand, but
well,
if
here's
your
going to be
final
the
settlement
problem.
is the 5th, and you're asking for
Oh,
final
okay.
settlement on the 3rd, I can't get notice to my witnesses in less than 48 hours.
That's
They're-
correct state.
they're also like law enforcement though too, right? Witnesses?
I understand that, but it is still a matter of scheduling for them, and I can't get them in 48 hours. That's not
She
reasonable.
can't do it, and I'm not going to make her do that, even if she could.
I'm just trying to find ways to be accommodating and move cases along. I mean, that's all, and that's the best.
I
we can really
understand that's what you're
offer.
trying to do, but you're not being very accommodating now, because I could just set, if he wants a jury trial, here's going to be the problem. If he wants a jury trial, then it would be the 5th and the 8th. Otherwise, my next jury selection is in June. Now, I realize that may not be a issue for Mr. Bloom, only because I think he's in custody on other matters. But still, that's,
Well, I suppose we could just set it for, I don't even want to set it for a final pretrial if it's not likely to go though.
Your Honor, my suggestion is that if we want to set it for final settlement, we set it today, leave it on the 4-3 docket, and at that point, I'll send out notices today, and then I can call them off. What I don't want to
do what?
I can call off my witnesses so they don't have to appear.
So you want me to set the 3rd, the 5th, and the 8th?
That would be my suggestion in order to accommodate.
Accommodate the prosecutor.
And I can be in touch with Ms. Barroso in advance if things aren't looking like it's going to happen. And maybe make her life a bit easier and calm off early.
I actually get to see Mr. Bloom 3 times.
We'll take your next 8 court dates available, Your Honor.
Well, I've been fighting this for 5 months, so.
What?
I've been fighting this for 5 months of simple misdemeanors, so,
No, yeah.
Who cares?
It's 3 times. All right.
Who cares?
Here's what I'll do. I'll adjourn the pretrial April 3rd, 2024, 9 a.m. I will also set jury final settlement conference for April 5th, 2024 at 9 a.m. And then I will set jury selection if necessary for April 8th, 2024 at 8:30. All right, and then we'll see where we head from there.
I'll be in touch with Ms. Barroso and I'll cancel any appropriate court dates. I know the court likes when I'm here with Mr. Bloom frequently, but if I can, save any future court date, we will. Wait, Jeff, was this for me?
Yes.
Okay.
All right. Thank you, Mr.
Your Honor,
Oh, boy.
I always want to put something on the record.
Yes.
I am requesting.
I was hoping I'd escape.
Right. But it's always-
I was hoping I escaped it. Bloom.
I'm always an issue.
All right, go for it.
This is the thing.
All
For
right.
our last court date on, what was it, 3/6, I am requesting the transcripts and the so-called notes you received from Wellpath and Lieutenant Arnett concerning my tooth extraction, where they said I
Hold on,
would take
hold on.
injections,
Can I see the file again?
where I would
That I received?
injections in my mouth, Novocaine, but I wish to be put under for a simple tooth extraction.
Mr. Bloom.
I am requesting those transcripts and these notes.
Transcripts of the last proceeding?
Yes,
Okay, you can ask counsel. He knows how to get.
I'm just putting it on record.
Okay, then
And the notes that you received,
notes I
yes, that you
received
stated on the record.
that I
you
had a
received
conversation, yeah.
from Wellpath and,
No,
people
I
who
have
charged
not
you
talked to
with this crime.
Wellcat. I've not talked to
well,
anybody.
you received notes from someone saying that
No.
I refuse to take injections in
No,
my
I
mouth.
received, that was a oral communication
Oh, well,
saying
okay.
that was it.
Told
And
me it was notes.
I informed the parties exactly of that communication.
Well, it was a blatant lie. My religious beliefs tell me not
I
to
don't,
take any
Mr.
medication,
Bloom,
sir.
I don't know. That's why I
Well-
informed everybody.
Well, you
of
took
what
it
I
as
had
me,
heard.
so I just wanted to put that on record. Thank you very
Okay.
much.
Always a pleasure.
Mirage. Oh, that's right. How you doing today?
Great, sir, thank you.
Wow. Is that your friend? No, hey, never mind. No, I'm just asking.
Today's hearings demonstrate that every courtroom operates under the same guiding principle. Decisions are based on law, procedure, and credible evidence, not emotion alone. In the first case, the judge denied the motion after determining the legal argument had not been raised in a timely manner. In the second, the court postponed a final decision to ensure the alleged repair issues could be properly inspected and documented. And in the final criminal proceeding, the discussion centered on scheduling, witness availability, and preserving the record rather than deciding guilt or innocence. Every hearing highlighted how important procedure is to achieving a fair result.